You've been charged with a Class B misdemeanor obstruction of a highway. The range of punishment on that type of offense in the state of Texas is up to 6 months in the county jail and a $2,000 fine. That bond has been set at $3,500.
Welcome back to Time Served, the channel that scans the docket so you don't have to. I'm Phil, and boy, do we have a docket for you today. We have Judge DeSanto, Judge Braunlick, Judge Sheila Johnson, and the one from DeSanto, I must say, she is quite the Jersey girl. You'll see. Make sure you hit that like and subscribe, set your notifications to all, and never miss the daily dockets. Court is now in session. Let's roll, nerds.
Can you please tell me your name?
Jean Walls. Jonan is my maiden name.
Stand up.
Well, what is your current name?
Kimberly Jean Walls.
So then why do we have Kajonan? Why are you telling us your name is Kajonan?
I messed up and put Jonan, my maiden name.
All right. All right, Sergeant, if you could please raise your right hand. Solemnly swear from the testimony about to give this matter to be the truth, the whole truth, and nothing but the truth.
Yes, I do.
All right, thank you. And you may proceed on the warrant.
Your Honor, on August 2nd, at approximately 3 a.m., Walls was the passenger in a vehicle that was stopped for multiple traffic violations. The driver, Walls' son, was arrested for OWI in possession. During an inventory search of the vehicle, Walls' wallet was found inside. In her wallet was a tied cell phone baggie containing heroin and fentanyl. Also within her span of control inside the vehicle was crack cocaine. Both the cocaine and the heroin and fentanyl field tested positive by Officer Adam Grove. Nothing further.
Has examination of complaining witness, I find that the offenses charged were committed and there's probable cause to believe the defendant committed the offenses. All right, and counsel asks for the arraignment.
Your Honor, I'm confused in that the information that I got, count 3, as an operating while visibly impaired charge against my client. Is that an error?
Warrant is
It
correct.
says against defendant, it says defendant 2. Defendant 2 is Travis Walls.
Oh, all right. I see that now. All right. I didn't see it initially. Traverse Walls. Okay. All right. And yes, Your Honor, as to arraignment, we waive form reading, stand mute.
At making false allegations.
All right. The court is going to waive the formal reading. Ma'am, you have the right to have an attorney represent you. If you cannot afford an attorney, one will be appointed to represent you. And in fact, you've had an opportunity to speak to an attorney today, correct?
Yes.
You also have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury, and you also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, ma'am?
Yes, ma'am.
The court's going to enter plea of not guilty on your behalf. Schedule this matter for probable cause conference on August 10th at 9 a.m.
Do I have a bond, ma'am?
We're going to address that, ma'am. Counsel as to bond.
Your Honor, my client tells me she's 46 years old. She has a GED education. She tells me that she's not on probation or parole and has no other cases pending that she's aware of. And Your Honor, she presently receives Social Security disability. The nature of her disability, she's under doctor's care. She attends a methadone clinic every day. She acknowledges her problems with drugs. That's why she's on the methadone and she's under doctor's care. Your Honor, she has no children. If released, she would go back and live with her mother in Monroe. And Your Honor, in criminal history, yes, she does have some criminal history, and it comports with the charges. We asked the court to, in its discretion, give a bond she can reasonably expect to post and continue her treatment. Thank you.
Excuse me. Okay, did you say she doesn't have any children?
She tells me she supports no children right now.
Oh,
I
supports
do
no
have children, I
children.
just don't
She's
support
recently
me.
widowed.
Ma'am, if you're in a test today, what's in your system?
What was she say? If I was to test today, what would be in my system?
Correct.
Probably cocaine and fentanyl. Methadone.
And you don't work?
No, I get SSI.
What's the basis of your disability?
My mental health.
Are you in treatment?
Yeah, I'm in methadone. I do counseling and I go to methadone every day.
Okay, methadone every day isn't necessarily mental health treatment, ma'am. You say you go to counseling, what does that mean?
I go to counseling through the methadone clinic.
Are you currently on probation or parole anywhere, ma'am?
No, sir. No, no, ma'am.
Are you out on bond in any other jurisdiction?
No, ma'am.
And you live in Monroe?
Yes, ma'am.
And where does your son live?
My son lives in Monroe also. He doesn't live with me though.
All right, Sergeant, as to, bond.
Good morning.
Your Honor,
I could have you state.
her criminal history is extensive. There's a habitual offender notice attached to the current charges. And she also currently has an out-of-state warrant for narcotics with a $30,000 cash bond. Considering the circumstances, I would recommend a $50,000 10% bond.
What state is that, Sergeant?
Atlantic County Sheriff's Office, Jersey maybe?
2004.
I should take a look at that.
Oh, I see, yep, New Jersey. And why don't there be a protective order, ma'am?
Protective orders.
Please.
What do you mean?
Well, there was a message entered into lien regarding not being able to carry a license, a gun, not having any contact with a protected person, not going to this person's property.
I'm not sure. I don't know what you're talking about with that.
Well, would that be from your matter in Monroe County for a felony domestic violence charge?
That could be from domestic violence charge, yes. But that person has passed away last week. That was my boyfriend of 25 years.
And how did your boyfriend pass away, ma'am?
He had rhinitis, some kind of infection in his heart.
Who's Helen Mullins?
My mom.
Was there a case with your mom as the complaining witness? Or is there a personal protection order with your mom as the protected person?
No, she's the one that bonded me out.
Well, ma'am, perhaps you haven't been served with that yet, but there was a PPO entered without a hearing with Helen Mullins being the protected person.
Okay, yeah. Maybe she hasn't give out that, but she will be the one helping me find out.
Ma'am, you cannot contact her.
Oh, okay.
She's a protected person. You cannot contact her, whether to post your bond or otherwise.
Okay, sorry.
And so the court's going to indicate, based upon the charges, based upon the criminal history, the fact that this is a habitual offender, second offense notice, and she's looking at an enhanced penalty upon conviction, and the fact that there is a warrant out for her arrest out of New Jersey for the same type of charge. The court's going to indicate that a $50,000 10% bond is appropriate, no surety.
Oh, wait, $5,000.
Yes, ma'am. In the event you post bond, who lives at the home with you, ma'am?
My mom.
When's the last time you were at that house?
2 days ago.
Well, that seems to be when this order was entered, so you can't go back there. Where else would you be able to go?
Probably my boyfriend's son's house.
Which would be where?
Taylor.
The court will indicate a GPS tether. And you'll have to submit to random testing, not to possess or consume any alcohol or drugs unless prescribed.
So I have to get a tether on today?
You have $5,000 to pay today?
I'm trying to get one, and I'm gonna try to get it. I have $1,000 today. I have $1,000 today.
Well, if bond is posted, you cannot be released without a GPS tether. If you do post and you have the tether, then you need to report to the 27th District Court probation immediately upon release.
Okay. I also may be able to live with my aunt that's in Monroe too.
Hey, ma'am, you're indicating that you're not working, but you have $1,000 that you can post towards your bond?
It's my SSI check.
Okay, we will see you back on August 10th.
Okay.
All right.
Thank you, Your Honor.
Let's handle this file on my tape first. Let's handle, thank you.
Shawnee Chaffee.
Okay, thank you. And I have Attorney Sabah. Are you in the same office?
That's me.
I thought you said Mateo.
No, I said Mohammed Sable.
Oh, Mohammed Steve. I thought you said Mateo at the end. Okay, I
Oh, no, I'm
apologize.
not Italian. I'm sorry.
Okay, okay, I'm sorry. I misunderstood what you said. That's why I was a little confused. Okay. All right, today's date scheduled for the exam in council.
Your Honor, at this time, after speaking with the defendant and prosecutor, defendant would like to waive the exam and have this matter be bound over to Wayne County.
Okay, and the people are in agreement with that?
That is correct. There's no objection, my opinion.
Okay, and Ms. Chapel, you understand that you do have the right to have a preliminary examination where it must be shown that a crime was committed and probable cause exists to charge you with that crime.
Yes.
You also understand that by waiving your right to your preliminary examination, you'll be bound over to circuit court for further proceedings on the charges in the complaint.
Yes.
And you have received a copy of those charges. You are aware of what you're charged with?
Yes.
Okay. And has anybody promised you anything, threatened you, or coerced you in any way for you to waive your right to your preliminary examination?
No.
All right, the court will indicate the examination having been waived. Defendant's bound over circuit court for further proceedings. You are to appear in circuit court on August 17th at 9 a.m. on the charge of the complaint. And the court will indicate bond and conditions are continued. Anything else?
If we could, I wanted to address bond if possible, Your Honor.
Okay,
Currently, defendant is on a tether, and the tether, as you know, has to be paid either daily or weekly. She's currently applying for the Wayne County, Wayne Community College dental program. It's a prerequisite 6-week externship, and it costs about $500. She would not be able to afford both. She's currently on probation and dropping due to the current mental charges. So she wanted to know, and we wanted to know if we could revisit maybe removing the tether off of her leg, so she would be able to attend the externship and pay for it.
I'm sorry, you said that she's currently on probation?
Yes. That she told me she's on probation, she's dropping.
Okay, I thought you were on probation a couple of years ago with this court.
Yeah, but when my first court date, I went over.
Those are bond conditions, testing for bond conditions.
Okay.
That's, I was a little bit confused.
As was I.
Okay, and the tether was a GPS tether, so that the court could ensure the safety of the complaining witness in this matter based upon the allegation. And so you're asking for the GPS tether to be removed, and that's the only condition?
Yes.
All right, and Mr. Shadra, your response.
Judge, the people would object to any bond reduction in this case, given its serious assaultive nature, judge, and its egregious nature. The complaining witness in this case was working at the Wendy's, judge, and he was attacked unprovoked by the defendant. Condoms were thrown at him. A steel tray was also thrown on him, judge. We asked that the court actually remand the defendant in this case, judge. We know that there's a full extradition warrant out of Inkster for another assault and battery, judge. And we would ask that the defendant be remanded back into custody.
There's a warrant?
Yes, judge, there's a full extradition warrant out of Cindy Inkster for assault and battery. And if this court allows, I could approach with the lien paperwork.
Yes, because that warrant's been confirmed?
Yes, Judge, we just read this lien report, myself as well as the OIC, about 10 minutes ago.
Okay.
Yes, Your Honor. Defendant has relayed to me that she missed her court date in Inkster. Those charges were looking to be dropped. She did miss her court date, but they sent her a new one, and she should be appearing.
Hey, Judge, for the record, there's also a failure to appear history for traffic offenses as well.
Okay. We have a warrant out of Romulus from November of 2022. 18th District Court for probation violation. What are you on probation for out of Westland?
I was never on probation in Westland.
Well, the 18th District Court is Westland. And the date of the warrant was January of 2023. Let's see, reduced. Criminal benchmark for probation violation, failed to appear for a show cause on November 14th of 2022. failed to appear December 12th of 2022, failed to appear after the 14-day letter, $540 bond, or $540 what you owe, $6,000, 10% cash surety. Then Inkster gave the warrant February 8th of 2023 is when that warrant was put into the system. Or you failed to appear for a pretrial on the assault and battery. And malicious destruction of personal property. And then a warrant just went into effect July 27th for Southgate. You failed to appear because you failed to appear for a show cause on the handicap parking violation. Well, I guess I'll say I feel privileged that you show up for our court dates. Who's the complaining witness in the matter in Inkster?
It was my ex-boyfriend.
And you should be a little bit louder, ma'am.
It was my ex-boyfriend. I showed up to the one court date. I missed the second one. It was getting dropped. I missed the court date. I called Inkster. They said if I paid the $500, it would be dismissed.
If you pay the $500, it would be dismissed. That's not really how it works.
If I show up, get a new court date, and just pay the 2 tickets that I have, it was going to be dismissed. That's what they told me on the phone. So I'm just waiting for my new court date to come in, and I can pay the $500.
Did you post a bond?
No, that was going to be the $500. She told me to come pay.
I believe for missing.
Right, and so how are you getting a new court date if you haven't even posted a bond yet?
She told me to come up there and sign a paper. I wouldn't have to go through that. I don't know.
And when did they tell you that?
Like a week or 2 ago.
So did you already do that?
No, I have not.
Why not?
Because I don't know that.
Because why?
Your Honor, I believe
I don't have the funds right now for it. I pay out of school pocket. I pay out of school $500 a month. I pay for the tether. I pay for dropping. I don't have my family. My mom's in Alabama. I'm doing this on my own. I don't have it. Like that's why I'm trying to get off the tether. I can pay my tickets and clear the warrants, but I can't do everything.
But ma'am, you've had months, and in some of these you've had over a year to do that, and you haven't done it. And there's an extradition warrant out of Inkster, so you're gonna be taken into custody today. So because you'll be taken into custody, they're going to remove the tether, so at least that part's done, but, so the court will, indicate that defendant will be remanded to custody. Okay, ma'am, you're gonna be going with the officers today. Thank you.
Your Honor, Andrew Tapal on behalf of the people.
Good afternoon, Your Honor. Michael Gichuku, PA 2535, on behalf of Mr. Julian Poplin. I'm standing in for Mr. Bonnet, who's the attorney of record.
Okay, let's wait to see. We got Mr. Poplar here.
Thanks for
He's walking up right now.
Okay. Okay, Mr. Poplar, tell us your name.
Julian Maurice Poplar.
And Mr. Poplar, we have counsel here today standing in for Mr. Gonick, your counsel of record. That's the lawyer there. Just for today's hearing, do you mind?
No, I don't mind.
Okay, and so for today, we are here for a probable cause conference. The charges, of course, are larceny from a person, I believe. There are 2 counts, each count carrying up to 10 years in prison. So you do understand what the charge is, correct?
Yes.
And you do understand that you do have a right to have your preliminary examination fairly quickly, within 21 days of your original arraignment date. And 7 days from the original probable cause conference date, which you didn't appear at, and we didn't know where you were, because we were told you were no longer in Macomb County. But you could probably at least have it quickly from today's date. You understand that, sir?
Yes.
All right,
And Your Honor, if I may,
what's going on?
just to clear a misunderstanding which seems to be happening since last time, the court did indicate that he failed to appear last time, which was July 7th. I did have a discussion with other counsel this matter. I also did have a discussion with the defendant's mother, who is present in the courtroom today. It is my understanding that Mr. Poplar was never released from Macomb County Jail, and that he has been in, at least from the Macomb County Jail inmate locator, has been there since March 1st. So I don't know who sent that message out to this court, whether that he was released or not, but I did wrote in my notes that date and times for BCC, defendant failed to appear. The defendant was supposed to be in Macomb County Jail. Macomb County Jail indicated that he's no longer there.
That's what I am.
So
who knows what happened, but.
I don't know what's happened, but
today.
I just want to make a record that I'm not gonna hold that last hearing against the defendant. And, I'm not gonna consider that. It's not gonna affect how I handle this case. Is that what we discussed, Court Counsel?
That's correct, Your Honor.
All right, so what do you want to do today?
I want to set a date for an exam.
Okay, set it for an exam. How many
Excuse me.
witnesses?
Excuse me,
sir.
Your Honor. In this matter, the only reason I've been able to get court dates was because I sent the court a petition, a writ of habeas corpus, and I sent the habeas corpus, which stated on it that it was 10 days that I had, that the court had to bring me before a judge. And I'm sorry, I don't have the form on me right now. I thought I did, but it has exceeded that 10 days. And I just had my mom, who has been insisting me a lot on these matters, to call the court clerk this morning, and the court clerk did verify that they received the habeas corpus on July 14th. So now it is set. It is now 4 days past the 10-day rule in that petition.
Okay, sir. We scheduled this matter according to what we could do and what Macomb County could accommodate us on the Zoom. I'm not dismissing the case because we didn't bring you physically here. We brought you here on Zoom. And all they would do is rewrite the case anyway. It doesn't make the case go away.
In the petition, it stated that if I didn't be brought before the court in a timely manner, that by the court's own motion, the charges be dismissed.
Okay, that's what your petition says. I'm not doing that, though. It's my motion I have to make, and I'm not making a motion to dismiss it because we got you here.
But
and if you and your lawyer
it's
would
not
love
within
to,
the 10 days.
If you and your lawyer want to brief the law on it and make that motion, you can. But I'm not doing that today.
I haven't been able, Your Honor.
Sir, you're gonna have to go through the whole process again. It's not a permanent dismissal. They would just rewrite it. You would have to go through arraignment again, and we'd be right back here. That's the way that would happen, even if I did dismiss it. But if you want to
Okay.
brief that, you can.
Okay, Your Honor, I
For
understand.
example, anything that
But I-
people did delayed this process intentionally. I mean, I'm pretty cautious when it comes to.
No, as soon as we got this, we asked to have it set. I set aside the warrant, to set it for a probable cause conference, and this is the quickest day that they had.
That's correct.
So that's what
Okay,
we
Your
did.
Honor, I still have something else to say, please.
Well, let me ask
So
you a question, sir.
my
Do
bond
you
was
have a
raised.
lawyer? But why
Yes,
do you
I haven't
have a
even,
lawyer?
I
If
don't, I
you're gonna
haven't
do
been
it
able to
with the-
speak to my lawyer. I haven't been able to speak to my lawyer since this case has been on the docket. My lawyer has not reached out to me at all.
Okay, well, you wanna give the message to Mr. Golick, he probably needs to do some kind of video or in-person visit over there to Macomb County, whatever they do. Cause
That's what
the client is struggling without having talked to him.
Everything we discussed today, we relate to Mr. Golick.
He said he's gonna make sure the lawyer gets to you either by video visit or directly over there to the county jail to visit you, because it's not that far. So what else you want, Mr. Poplar?
Yes, and also the bond, my bond was raised for me for apparently missing the last court date.
Sir, I
when I
fixed
was
that.
in.
I fixed it. I fixed it. I recalled the warrant and reinstated the bond.
I was hoping that I would be able to get a personal bond.
Sir, you're already incarcerated for something.
If I may,
Yes,
Your
but
Honor,
I'm-
even
It's what your own department tells
does
you.
have holds from the Frank Murphy court. Also, he has no bond, I think, in one of the charges out of Macomb.
I'm not changing the bond at all until after the preliminary examination. If you and your lawyer would like to make a renewed motion about the bond, based upon some facts and information, not just because you want to get out, then I will listen to it, for sure. But I'm not can't do anything today, and you can't go anywhere anyway.
Yes,
This
well, I'm
judge.
working very hard to get get out. That's what I'm saying. So I need things to work in sequence. And if I have one thing hanging over me, then it's gonna hurt the next thing. Just like how he just told you. Well,
Sir,
I got bonds over here.
I'm not sure why you got so many things hanging over you in the first place. Why if you're in, it's because of something you may have done. May have. So I don't know why
Yes.
you got so many things out there that you're struggling to try to get free on. I don't know anything about this case at this point, Mr. Poplar, so I'm not changing the bond. I have heard no abuse of discretion in setting the bond or anything at this point. So if you would like to have your lawyer address that at the next court date, especially after we hear some evidence, perhaps it might be in order to give you a bond reduction. But there's no basis to do that now, and you haven't shown any abuse in what was already
There was sufficient
set.
evidence.
And I did fix it where I reinstated what was already forfeited and how it was increased. So the original bond in this matter from the arraignment, let's see what it was. Arraignment date, it was a $500 cash assured bond. So that's what you got back. Doesn't get too much lower than that for 2 alleged larceny from a person, 10-year felony counts. So, how many witnesses, Mr. Topali? Okay, no cursing.
Yes, ma'am.
How many witnesses?
4 to 5, Your Honor.
4 to 5?
Yes.
Oh, gee. Mark. I know.
If he's being held to bond.
Not on this case, he got a bond. I don't know what the other one.
Your first day where you've got nothing going on except one sentencing, September 14th.
Okay.
The other days you have 2 exams.
No. September 14th would be good. What time?
9:30.
9:30. And that's free. That whole morning, too?
Yes,
I don't see any other things. that
one
we-
sentence advance.
One sentence. Can you make sure we keep that free, because we got 5 witnesses?
I will.
Okay. So that is the exam date. His bond is reinstated.
Make 9 o'clock.
Yeah, let's make it 9, okay.
I thought the preliminary exam had to be 21 days out.
That was from your original arraignment date, sir, and you weren't here. We didn't know where you were. So that would have been 21 days from the original arraignment date that the warrant got issued, so.
You
that's
said,
fine.
okay.
21 days from June the 26th. We way past that.
So you saying I'll waive my 21 days being waived?
Yes, because you weren't here on the date that we were scheduled for, and we did not know where you were. So we can't go 21 days from your arraignment, because when we were here, you weren't, and we had no idea where you were. We just found out where you were, that you was in the jail.
It's because I haven't been able to talk to my lawyer. My lawyer won't even answer my phone calls from the jail.
Well, if it's a collect, I don't know if you.
No, I have a prepaid.
You got money on a
account I can call.
card? You got money on it?
Yes, I have. Yes, I can call anybody in the United States.
Okay. Mr. Golding needs to get on back. With this phone here. I'm gonna get on him when we come back.
I understand that. I'll relay the message.
Okay.
I didn't even see my attorney before I came up before you, Your Honor. I'm just now, they just threw me
We
in
got
here.
you, Mr. Poplar, we got you. Now, if there's some more problems, I'll handle it when he gets here on the next date. So you just keep track of what you think he didn't do. But if he gets there, he talks to you, and you all go over whatever you need to go over, then you should be good to go. Okay. So September 14th, 9 a.m., and we will need a video. No, we're gonna need him a writ to get him out of Macomb County. So can the people make a note of that?
Yes, Your Honor, I'll take care of that for sure.
From Macomb County Jail, so he can be here in person for his exam. All right. All right, that's gonna conclude this matter for today.
Thank you, Your Honor.
Okay, all right.
Court is now in session. Amber Merritt versus Ian Smith.
Are you Ian Russell Smith?
Yes, sir.
All right, for the record, Mr. Smith is appearing from the Calhoun County Jail, having been arrested on a bench warrant issued by this court. Also
Yes.
present is Patrice Patrick, Monroe County in front of the court. This hearing is being conducted via Zoom. Mr. Smith, do you have any other, do you have any criminal charges pending, or are you in jail only on this warrant?
I'm in jail only on this warrant, Your Honor, and I can't afford, I can't even pay the bond, Your Honor. I haven't, I just moved
Okay,
out of
Mr.
Monroe County.
Mr. Smith, who is supporting you right now?
I'm at a homeless shelter. I just got a job. Me and my fiance that I'm with now, we have twins. We moved from Monroe County when I got off parole and moved to Battle Creek. We have no money. Like, I can't even pay the bond.
You and
I
your
just
fiance
started a
both
job.
live, do you and your fiance both live in the homeless shelter?
Yes.
Okay.
And I just started a job. I just got hired last week, and we're trying to find housing, and I just got hired, and I don't start until next week, and I got hired at Wendy's. Like, I have had problems finding work because of my criminal background and everything else.
What about
And
your
my
mother?
mental health.
can your mother post a bond on your behalf?
We're all broke. Like with everything
So-
the way it is right now, nobody has.
I'm asking
any
about
money.
your, do you have any family members, like your mother? Can your mother post a bond on your behalf?
I don't have any family. All
Oh,
I have
okay.
is my fiance and my kids. And it's like my family, I don't talk to my family. Like
Well,
I'm alone
so
with my
did you have any money in your property when you were arrested?
no. I'm at a homeless shelter.
I understand, Mr. Smith, we just answered the court's questions. I'm asking, did you have any money in your wallet when you were arrested?
No, sir.
$20, nothing?
Nothing. Like if I didn't known all this, I would have been making payments. I don't have any money. Like I have five kids.
Mr. Smith, I can tell you, come back to Monroe, I have a 4-page list of employers that are screening for employees. I could do a job today.
Yeah. There.
So come back to
There we
Monroe.
go.
I don't know about where you're at in Battle Creek, but in Monroe County, there's a lot of jobs. I get you a job immediately. So don't tell me you
Sir,
can't find a job, Mr. Smith. I'm not going to accept that.
It's not that. I can't be in Monroe County because of my history.
Okay.
Of
Well, you need,
my drug abuse. That's why I moved
Okay.
away. That's all. That's all.
but you're ignoring your obligation to pay child support, Mr. Smith. And don't tell the court you didn't know about it. You have children. Yeah, if there's a court order that you pay child support, don't tell me you're not aware of that court order. When you're not working, you need to contact in front of the court. You're sitting on your hands. You're ignoring the obligation. That's why the bench warrant issued, Mr. Smith.
Okay, but I wasn't informed. My grandmother has dementia and everything.
Hold
So
on,
she's
hold on, Mr. Smith. Miss Patrick, when was the original support order entered in this case?
The original court order of this case is 2010, Your Honor. This child was born in 2009. The address that I asked Mr. Smith this morning or this afternoon, he gave me the same address that we mailed the hearing to. He had been working with the friend of the court up until March of 2022. He provided his mental health and everything. Then in February of 2023, Mr. Smith did not appear, did not contact this agency. It is arrears only. It's $17,318. So at that point, we were forced to issue the warrant because we had not heard from Mr. Smith. He had not contacted us. He did not appear. So we have tried to work with him. And also, Your Honor, speaking of the warrant that is there for his arrest, the friend of the court at this time is asking for that to be rescinded and canceled.
Right. Mr. Smith, do not tell the court you didn't know about this child support obligation. It was entered over 13 years ago.
I know, Your Honor. There's no excuses. I should have been paying. I apologize. I've just been going through a lot with my drug addiction and my mental health and everything else. And I'm trying to get that all figured out now. And I'm starting new here in Battle Creek, and I'm going to stay here with my family. And I'm going to start getting things together. I did get hired next week. I did get hired last week at Wendy's. I start this coming up week. I can start making payments as soon as I get my first check.
Well, actions are louder than words, Mr. Smith. Do you own any property of any value? Do you own an automobile?
No, I don't have anything right now. I'm walking everywhere. Like, I'm trying to get things together.
All right, so Mr. Smith, I'm going to give the benefit of the doubt and authorized release on a personal bond, but we're going to give you a date that you need to appear for a hearing. You'll appear for that hearing, bench will issue, and rest assured, you're going to sit in jail until you post a significant cash bond if you blow this next court hearing date off.
I won't, Your Honor. I won't. You have my word. Thank you.
Ms. Patrick, what do you recommend in terms of review dates?
Your Honor, we would recommend,
I'll be there.
well, you don't have to be there, sir. You can zoom in, but I would recommend September 19th at 3 p.m.
And this would be on Ms. Six's docket, correct?
Correct, Your Honor.
All right.
Would you like me to have that as no bond, Your Honor, or a PR bond?
No bond required.
Thank you.
A PR bond really doesn't mean anything, so no bond required. I'm giving you benefit of the doubt, Mr. Smith. You burned me once, you're gonna serve some significant time in jail.
Okay, I won't.
You were ordered to, I don't know if you have a piece of paper and pen there, but you're ordered to appear before the front of the court attorney September 19th at 3 p.m.
September 19th.
It's a Tuesday. Do you have a piece of paper and pen there or not?
I'm also going to need a fax number, Your Honor, to be able to.
All right, hold on, Mr. Smith, sit down. Mr. Smith.
Okay.
Just have an
Yes,
officer
Your
come
Honor.
in. We're gonna get a fax number from the officer. We're gonna put this in writing. We're gonna fax a copy of this order to the jail, and you'll get a copy before release. They'll have the Zoom ID
Okay.
number on there and the date, September 19th, 3:00. It's a Tuesday. If you don't appear
Tuesday.
at that time, the bench will issue for your arrest. When you get picked up in the bench, it's just a matter of time, Mr. Smith. You're gonna serve time in jail. So get your act
Yeah, I'm
together.
not-
What you do is you go online or talk to your caseworker, file a motion to reduce support. I mean, if
Okay.
you're not working right now, or your wages at Wendy's are not very high, you may want to reduce your support obligation rather than dig the hole deeper. And if you don't start making some progress in this matter, the Attorney General is going to charge you with a felony of non-support with those kind of arrearages,
Really?
17,000 in the arrearages.
I didn't know this. Yeah, I want to get this
Well-
taken care of because I have been trying to get my life back together and I don't want.
Well, get into
You know.
treatment, Mr. Smith. If you need mental health treatment or drug treatment, get into treatment. Get your life together. So see if you can get a
Okay.
corrections officer to put his head in, so we get their an address, an email address for them or a fax number. Is there a corrections officer outside the room there?
No, he's kind of like just staring at me and I keep trying to call him in and he's
Well,
just staring
Why
at
don't
me.
you just wave him in? Why don't you just wave him in? Tell him the judge would like to talk to him.
They want you. Yeah, he is just being a straight, wow, this county, man. He wants to speak. My judge is asking, why is he being?
Good morning. Good afternoon, officer.
Hello,
How are you today?
good to yourself.
Good. The court's going to authorize Mr. Smith's release on a no bond required. I've canceled the bench warrant, and we'd like to either fax or email an order to the jail so that a copy can be provided to Mr. Smith. What would you suggest? You have a fax number down in your intake area?
I'm need I need the email address. I don't know the fax number right off.
Email will work.
Okay.
Okay. You ready?
Mm-hmm.
CCSO video at Calhoun County.
Okay.
MI
Mm-hmm.
.gov.
Okay, so that's CCSO video at calhouncountymi.gov.
Yep.
Okay, I will email it to you. Thank you very much.
Thank you.
All right, Mr. Smith, you're all set. We'll get a copy of the order down. Thank you, officer.
You're welcome.
You can step out,
Thank you.
sir. You can step out.
Okay.
Right,
Thank you.
we're done.
Wait,
Welcome.
all right, thank
Thank you.